Court of Appeals, Division 1 is now in session.
And good morning, folks. Please have a seat. All right, and welcome back to being in person and without a mask if you're comfortable with that. So please feel free to remove any. I don't actually see any here today. First time I think I've walked out and seen that in quite some time. We are here for oral argument today. It's 1 CACV 20-0497 Parsons versus Arizona Department of Health Services. As you know, we record these proceedings and they are live streamed. So please give your name and the name of your client when you begin your argument. According to the current protocol, which some of it does continue, you will argue from counsel table. You have a maximum of 20 minutes per side. You don't need to use all of that time, so please choose how to use your time wisely. You do have to keep track of your own time. It's a little less convenient when you're arguing from counsel table, I know that. You should be able to see the clock. If you can't see the clock on the podium, you're welcome to move around so that you can. The clocks show the time remaining, not the time that you have used. So that is your remaining time, and that includes any time that you choose to save for rebuttal. I'll also try and give you some signposts if I think it's appropriate. Please keep in mind that we have read all the briefing. We have studied the record, and we have discussed the case in conference before we came out here today. So with that, counsel, you may proceed.
Thank you. Your Honors, it's a pleasure to be here. And thank you for granting oral argument in this case. My name is Tom Dean. I represent the appellant in this case, Jimmy Parsons. And the issue here is, in generally speaking, whether the department exercised discretion properly in this matter when it denied Mr. Parsons' application for a designated caregiver registry identification card, or more specifically, whether the record contains substantial evidence that would justify the department's denial of that card, and or whether that denial was arbitrary and capricious. There are two conditions that must be met before any administrative action of discretion may be deemed proper. First, the department must show that it had the authority to exercise that discretion in the first place. The authority in this case for the department's discretion is found in ARS 36-804-05B3, which grants discretion to the department to either grant or deny an application where the applicant had a previous registry identification card revoked for a violation of AMA. But of course, simply having the power to do something does not ipso facto make the exercise of that power lawful. For example, having the authority to arrest someone does not mean that the arrest was necessarily lawful. With power comes responsibility. Accordingly, the second condition that must be met before a department's exercise of discretion may be upheld is the manner in which the department exercised its discretion must be proper.
Well, counsel, in that regard, how much do we peek behind the curtain to try and look at that? Mm-hmm. There's no requirement of written findings in the statute or even some sort of express findings.
So the case law indicates that there must be something in the record, that there has to be substantial, that substantial evidence is just that, evidence. There has to be something in the record, not just, for example, in oral argument, the department says, trust us, we did the appropriate consideration before we made this decision, we're just not going to tell you what it was.
Do you have a case that says when the department exercises its discretion, that somewhere the department has to show it to us?
Yes. So, for example, this court in Colfred, or let me just talk about the burden of proof real quick, Judge, I think may answer your question. This court in Webb versus State XREL Arizona Board of Medical Examiners, this court wrote, in reviewing the Superior Court's ruling affirming an agency's order, the Court of Appeals must independently examine the record to determine whether the evidence supports the judgment. That's under a preponderance standard. I think that case pretty clearly indicates.
But evidence? Because the evidence here is he did have a card rejected or revoked previously.
Right.
There's no time limit on that in statute. It's
Right.
just he had one in one point, and in this case, it was relatively recent. It was only a year or two earlier that it was rejected, maybe 3. And isn't that evidence?
I think that's evidence because, again, the first thing that the department has to show is that it had the authority to deny it all. They wouldn't have that authority, for example, if the individual who was applying didn't have a previous card revoked. They would have no choice but to grant the application. But here they're given the discretion to either grant or deny, and so that goes to whether they have the authority in the first place, but it doesn't go to whether or not that they justified that.
If you're saying we have to independently look at the record, I just made a point, which is the revocation wasn't old. It's not a 30-year-old revocation. It's one that happened recently.
Right, but
and indicated that he wasn't able to follow the law.
okay, and that's why the grant of authority is first there. But how does the department explain then why, in the same exact identical circumstances, they might grant another person's application? That's the definition of arbitrary. I mean, if they're
or
saying
discretion.
If they're saying we won't explain to you why we made the decision to deny in this case, beyond just telling you we have the power to do it. But we may grant another application filed later that same day under the exact same circumstances. We're just not going to tell you, court, so that you can't question at all what we do.
Isn't that an argument, really, counsel, that it's a constitutional argument that they treated him differently under similar circumstances? That's not a discretion argument.
I think, Judge, under ARS 12910E, it specifically says that the court shall affirm the agency action unless the court concludes that the agency action is contrary to law, is not supported by substantial evidence, is arbitrary and capricious, or is an abuse of discretion. Arbitrary and capricious that's exactly what that means. It's not a constitutional argument that the person's being treated differently under the Equal Protection Clause, for example, but rather the statutory authority right here in 910E talks about being treated in an arbitrary and capricious manner. And so without the department providing its reasons for why it denied the card in this particular case, there's no way that the court could ever know whether or not it was arbitrary, because it could just grant another one willy-nilly, indiscriminately.
And we have statutes, counsel, that require specific findings. And we have statutes that don't. This one doesn't.
Well, I think, though, judges, I believe that it still is subject to ARS 12910E, like all agency actions are. And that does require that they provide evidence that justifies their decision one way or the other. For example, the department didn't come in at any point during these proceedings before the ALJ or before the Superior Court and tell the court, here's evidence, we deny all applications where someone has a prior card that's been revoked. Perhaps if there was evidence on the record that was their policy.
But wouldn't that be changing the language of the statute? It says may. Why?
Right.
If the department were to come out and say we deny all, it would be changing the statute.
Well,
they have discretion by the plain language of the statute. Don't they have absolute discretion here?
No, they don't. They're subject to.
Why not? What kind of evidence would the department need to have produced that would allow us to affirm?
Well, it's a rational basis test, basically. The court doesn't have to agree with their reasoning, why they have decided to act one way and not the other. But they do have to explain why they're acting one way or another, not just say we have discretion, we're not accountable, we're not subject to judicial review, we make our decision and that can't be examined.
So could they have said, we Googled his name and your client's name and he had several traffic tickets?
I think yes. Probably.
You'd say that would be sufficient?
Arguably, yeah. I'm not saying I personally wouldn't try to say that would, but that would be a reason. And under a rational basis type examination, in the case law, virtually any reason is acceptable. And I'm kind of if I may, the ALJ in this case addressed this specifically and said on page 7 of her decision, and said that appellant's prior violation of AMA was innocent and unknowing, where a statute or regulation affords a state agency discretion, it must provide some articulable reason for its exercise of discretion. Because the department has not done so in this case, it should grant appellant's application for a caregiver card. Now,
Well, wait, because I'm just want to back up though. Is that an accurate statement of the law that they must provide an articulable?
Yeah.
Because again, written findings are not required here.
well, yes, because what the substantial evidence has to show is why they chose to deny rather than grant. That's the decision, that's the discretion. And they can't just, have a circular reasoning argument where they say something to the effect of, the department exercised discretion properly because the law gives the department to exercise discretion properly, which is their argument. It begs the question, what is proper? And what is proper is any reason, basically, that the department might articulate. In response to that ALJ's decision, the director of the department, who superseded it, I'm not sure if that's the correct word, but could have, at that point, in his final decision, said, we looked him up and he's got a lot of traffic tickets, therefore we think that he's still not law-abiding enough to trust with a registration card,
But
for
we
example.
independently look at the record, and we know that just a couple of years, not a long time, just a couple of years before, he didn't know the law well enough to properly fill out the form.
Mm-hmm.
Isn't that enough?
Well, Judge, if the department had made that argument, then that would at least be something that they could point to.
So now, I'll go back to a point you made.
Yeah.
If two people applied on the same day, and they granted one and denied one,
Mhm.
then it would be different. But that's not the case here.
We-
You don't have that example to say it's arbitrary and capricious. Two similarly situated people denied. What we have is one person denied a couple of years after he made a mistake. Granted, it may be a mistake, but we're also talking about giving caretaker status to somebody to take care of people who are ill.
Mhm.
Isn't it within the department's discretion to say, if you didn't know it a couple of years ago, we're not competent yet. There's nothing here to show that he learned something in those years either.
I think, Judge, that if we're talking about kind of, if they had made a distinction and said something like, well, because his mistake about the law was so recent in time, that therefore we think that it's not appropriate in this case. That's not the department's argument, nor did they ever put that on the record as evidence.
But they don't have to. But when we look at it, we're supposed to independently see if there's anything that can support the decision to deny.
Well, yes, but then we're back to saying across the board, everybody who has a prior card revoked then is ineligible, even though that takes away discretion. The department could just blanket, and if they, I think, that's speculative, what the department's policy is, because they've never articulated it. Is it a blanket prohibition? Anyone who's had a violation? In which case, I think that I think that would be problematic if they simply had a blanket policy that applied to everybody. I think that could even be argued as capricious, but that's not what we have here. And what they're pointing to, again, Judge, is that this factor that you're talking about, that he had a prior card revoked, is what gives them the discretion in the first place. They're then, I guess you could say, as you're arguing, they're then saying, based on that same reason, which is why we have discretion in the first place, that's why we're denying the application. But then again, is that across the board? If not, why in this case is it an issue? And I think that's what the substantial evidence is supposed to show, why the department chose one course of action instead of the other, rather than just say that it gives us the power to do so. And how do we know, is there anything on the record that the department has argued justifies their decision in this particular case to grant or to deny the application? Have they done anything to, I guess, identify this case as having some kind of a fact that would make them want to treat this case differently than another case where they might grant the application? If there's nothing in the record that in any way shows that this case is being, that there's something about this case that the department has taken into due consideration and articulated to the court on the record, then there's really nothing that we can point to that would allow the court to say this wasn't arbitrary. And Judge, I would also just, as a matter of public policy, I think if the court grants this here, that if it agrees with the department's argument here, that this is going to occur in all departments across the government, any area of discretion that you pointed out doesn't specifically say you have to have independent factual findings. Every decision is then going to be essentially not subject to judicial review beyond the department pointing to the fact that they have the power to exercise discretion in the first place. That, I think, is not acceptable. That's certainly not what the intent of the legislature was in 910E, and I think would dramatically shift the balance of power between the executive branch and the legislative branch if the executive was no longer accountable.
Isn't this part of the AMA? So it's actually the voters, not the legislature at this point.
Yeah, well,
We look at that a little differently.
okay, but I don't. If the court made a decision, this ruling only applies to voter passed ballot initiatives, then okay. But I think that when the court passes any case, regardless of whether it's a ballot initiative or legislation, it affects both in all cases. And I think that that's a public policy consideration that is very real, because this isn't in a vacuum. This particular case, this isn't like a specific medical marijuana issue that's never going to be relevant outside of the Medical Marijuana Act. This would apply throughout the administration. And I think, Judge, I guess it's an ipso facto, this idea that the reasons why the department has the discretion is ipso facto what then justifies that exercise of discretion is simply not what 910E was meant to, means. It means that there has to be some additional reason, just a reason, why in this case they denied rather than grant the application.
Let me ask you this. Is there anything that was manifestly unreasonable in their decision?
In their decision?
Manifestly unreasonable.
I think so.
What?
Well, first of all, they haven't provided a reason other than that they have the power to do so. But secondly, that...
But on its face, unreasonable. Not that they didn't provide one, but just on its face, you go, wow, I don't know how they did that.
Yeah, and I think that was the ALJ's opinion as well, was that, look, you guys haven't even given a single reason why you would want to take this guy's card away. The mistake of law that he made was innocent and unknowing. And they were invited to do that, Judge. They were invited to answer that question. The director had an opportunity to do it. He declined and instead fell back on his position. We don't have to. All we got to do is tell you we have discretion under the statute, and we don't have to explain that to anybody.
And you're at 4 minutes in case you want to.
Yes, thanks, Judge. I would like to reserve, if I could, for rebuttal, if it pleases the court, and I'll yield to the department in this. Thank you.
Counsel?
Thank you, Your Honor, and good morning. My name is Sean Moore. I'm with the law firm Sherman & Howard, and I'm here on behalf of the Arizona Department of Health Services. With me at council table today is Greg Falls. I think that the briefs have covered the issues fairly well, so my plan is to quickly run through the points made in the briefs to see if any questions you have, and then address the arguments raised by Mr. Dean today. So the relevant statute and the relevant regulation at issue here, those being ARS 36-2804.05B3 and AAC R9-17-205C1, are very straightforward in their logic and their application. It's a simple if-then statement. If the applicant has had a prior registry identification card revoked for a violation of the AMMA, then the department has the discretion to deny future applications for such cards of that person. And that's exactly what happened here. In 2014, Mr. Parsons had his original caregiver card revoked because he was wrongfully holding it in violation of the AMMA because he had an excluded felony offense on his record. That prior revocation meant that when he reapplied for another caregiver card in 2019, the department had the discretion to deny that application, and that is precisely what it did. So I'm going to jump into the merits of the dispute, but first we have to discuss the standard of review and the burden of proof. So the standard of review in this case is laid out, as Mr. Dean said, by ARS 12-910E, which relevantly states that this court will affirm the agency decision unless the denial of Mr. Parsons' application was without substantial evidence or was arbitrary and capricious. Looking at the substantial evidence standard, the court will look at the evidence in the light to affirm the agency's decision and will find substantial evidence if there is evidence in the record that could lead a reasonable person to the same conclusion.
And isn't that the point? Is we look at the record, and if we can find something, we say, well, there's something here.
That's exactly right, Your Honor. As long as there's something that could lead a reasonable person to the same conclusion, even if there's wiggle room in there that could lead other people to different conclusions, as long as there's enough for someone to say, yes, this was the correct conclusion, that's enough. Sorry, what did you say, Your Honor?
What are those things in the record? That we
the key things that the department had to prove and did prove was that Mr. Parsons in 2014 had a caregiver card revoked for violating the AMMA. He necessarily violated the AMMA because this court has previously ruled that his holding a caregiver card was improper due to the fact that he had an excluded felony offense on his record.
And I think counsel makes the point that triggers their discretion.
Right, that does trigger.
So what in the record do we have to say the exercise of the discretion then? So we know that they have it.
Right.
The discretion. So now we need something to support the discretion. Some.
Well, this is exactly where the burden of proof becomes important, Your Honor, because ARS 41-1092.07G1 says that when an applicant for a license or a card of this nature is appealing that decision, it is their burden of proof at the administrative hearing level. So, and this, I think, and I was going to address this sort of later on when I was addressing Mr. Dean's remarks, but this strikes at the heart of the problem with Mr. Parsons' argument. He continually says the department had to show X, the department had to show Y, but it's not the department's burden to show anything. As long as the department was able to establish sufficient facts to show that there was discretion to act in this matter, it doesn't have to show anything further. It's Mr. Parsons' burden to show that the exercise of discretion was arbitrary and capricious. And and to be successful on this appeal, he has to point to specific evidence in the record showing that the agency's decision was wrongful. Now, Mr. Parsons did not develop any such evidence at the administrative level. All he did was present evidence from the prior Parsons hearing in an effort to show that Mr. Parsons' violation was unknowing. But the knowing standard is completely irrelevant in this particular case, and Mr. Parsons did not take the opportunity to develop further evidence to show that there wasn't sufficient evidence in the record that to support the agency's decision, or that the agency acted arbitrarily and capriciously. And I think that that's sort of the central fault with their argument is they need Mr. Parsons to be successful has to show that the department's decision was wrongful. He can't just say, oh, the department, didn't prove what they needed to prove, because the burden of proof isn't on the department, it's on Mr. Parsons. So, getting straight into the merits proper, I think that it's pretty clear from the record that ADHS acted within its authority. As I mentioned earlier, it's apparent from the record that Mr. Parsons had the prior revocation take place because of his violations of the Medical Marijuana Act. And that's a settled fact. I mean, this court has already ruled that he violated the AMMA by holding the caregiver card. And so the facts that establish the department's discretion are already in the record and are not really contested by either side. And this gave the department the plain statutory authority to deny the application, which it did. And the analysis here couldn't be more straightforward. Now, the two things that Mr. Parsons brings up in order to try and overturn the agency action is he argues that there's no substantial evidence and that the decision was arbitrary and capricious. Now, as I mentioned earlier, the department doesn't have to affirmatively prove the negative of either of those things. It can do nothing and still be successful in this appeal. He has to prove that those conditions in 12.910E actually exist. But we believe that that evidence is in the record anyway, Your Honors. As I mentioned, the substantial evidence of the prior revocation gave the department discretion to deny. And as far as arbitrary and capricious, this standard is more of a process-based standard than a results-based standard. And the evidence in the record shows that the process that the department went through was honest and fair and that they considered all of the evidence or all relevant evidence. The testimony of department employee Nicole Heath shows that the decision was made honestly and with due consideration. When Mr. Parsons applied in 2019, his application was flagged due to the prior enforcement enforcement action taken against him. Ms. Heath then gathered the evidence relevant to his prior revocation and the violation, forwarded it along to an enforcement team of managers at the department, who then reviewed the information and decided to deny his application. There's no evidence in the record that any aspect of this process was arbitrary or capricious or worthy of overturning. And frankly, Mr. Parsons didn't do anything at the administrative level to try and develop evidence to the contrary.
The argument developed at the administrative level then?
What,
in other words, what was the argument that he put forth?
the argument that he put forth at the administrative level was that Mr. Parsons' earlier violation of the AMMA was unknowing because he didn't have the legal knowledge to know that the set aside of his controlled substances felony did not mean that, or meant that he did not have to report that when asked by a government agency, when in fact the set aside meant that he still did have to report that when asked by a government agency. So going into the arguments made by Mr. Dean, the first thing I want to touch on, because he brings this up several times in his comments, is he says that even if the department has the discretion to act under the statute, the department has to make additional showings because ARS 12-910E says that a department can't act in an arbitrary or capricious manner or abuse its discretion. But this is a misreading of that statute, Your Honor. That statute does not place affirmative requirements on an agency when acting. It's a standard of judicial review. And the standard of judicial review simply means that, certainly the agency action can't be arbitrary, but it doesn't place the affirmative requirement on the department to prove that it's not arbitrary unless the department has the burden of proof. In this case, the department does not have the burden of proof, and so it doesn't have to make that affirmative showing upon judicial review. Instead, because Mr. Parsons has the burden of proof, he's the one that has to go forward and show that there was an abuse of discretion here. He has to point to something in the evidence to show that the abuse was present. So I think that addressed the first thing that he brought up.
So let me
Sorry,
just
go ahead.
kind of in follow-up. It was on him to show, look, somebody else, same day, identical, or at least sufficiently similar, to
Exactly.
show this was an abuse.
Exactly.
Or the department has taken a manifest position that they never grant these.
Right.
Those kinds of things.
Exactly. If he wants to make those kinds of arguments, he could have developed that type of evidence in the record at the administrative hearing. And the opportunity was there, Your Honor. I mean, Ms. Heath was there on the stand testifying about the process that these go through and how these applications are handled when they've been flagged for prior enforcement. And Mr. Parsons did not cross-examine Ms. Heath at all, did not take any opportunity to develop that kind of evidence. And this strikes at the argument that he was making towards the end of his remarks where he said, oh, well, if we adopt this standard, then agencies can avoid judicial review. And that's just simply untrue, Your Honor. Judicial review is happening right now. The reason, the complaint that Mr. Parsons has that there's no evidence in the record to go towards arbitrary and capriciousness, one, is just objectively false because Ms. Heath testified to those issues. But two, isn't the department's fault, it's Mr. Parsons' fault. Since he had the burden of proof, he was the one that had to affirmatively present that evidence in order to be successful on his appeal, and he simply did not do that. As Your Honors mentioned, what Mr. Parsons seems to be asking for in this case is a list of factors to consider when a department decides to approve or deny one of these applications. But there's no such list in the statute. The statute's very straightforward. The only thing the department has to show is the fact that there was a prior revocation based upon a violation. That was done here. If the voters wanted to install some other requirements that the department had to show, that's fine. They could have done that. And they did in other parts of the medical marijuana statute. For example, 36-2815 requires a knowing violation of the AMMA to revoke a card that's already possessed by someone. That's one of the ways that the department can revoke a card that's already held by a patient or a caregiver. So there are other requirements that the voters could have put into the statute that they simply didn't. The department really only has to show the prior revocation based upon the violation, and then they have the discretion. And that's really the beginning and the end of the analysis. If Mr. Parsons wanted to overturn that, he had to develop the evidence and the record at the administrative level so he could come into this court and point to pieces of evidence in the record saying, hey, these are the reasons why the department acted improperly. There's no such evidence in the record, and therefore there's no reason that this court should not affirm both the director of the department and the trial court. And unless this court has any further questions for me, I don't think that I need the rest of my time.
I don't think we do.
Thank you, Your Honor.
Thank you.
Thank you, Judge. Well, that last statement, there's no such evidence in the record, is exactly my point. There is no evidence in the record. The department concedes that. They're asking me to somehow create substantial evidence to say it doesn't exist. If it doesn't exist, it doesn't exist. The department just said it themselves. They're asking me to prove the negative. I'm saying there's no evidence. There isn't. And now somehow I'm deficient in my burden of proof because I'm saying, look at it, there's no evidence. It just doesn't exist. We're being asked to just trust the department that they did the due process. They did the due process. Ms. Heath, trust her that she didn't act arbitrarily because she testified that she looked at the case.
And you don't dispute that they did look at it. They went through the process. They went through the hearings.
That it was flagged because of a prior revocation. I don't dispute that, Judge. But again, how do we know it wasn't arbitrary? Do we just trust the department representative who comes and says, I'm not going to explain to you, ALJ or Judge, I'm not going to explain to you how I arrived at my decision other than just telling you, don't worry about it. I took a look at it. I gave it due consideration. Just trust me on that. I'm a bureaucrat. You can trust me. That's basically what we're being asked to do, to give a lone bureaucrat, the authority to just say that she looked at it, and trust me, it's not arbitrary, but isn't that what the job of the judicial reviewer is to look at whether or not that's true? And if that is true, Ms. Heath, could you at least just explain just a little, why in this case you decided to deny rather than to grant the application? We don't need much. It's a rational basis test is what the case law is. No one has to agree with it, but it has to be rational. It has to be a reason that's not just, but speculative or hypothetical, and she just wouldn't do it. We're told that we have to accept their determination and trust that they did the process thinking it's not arbitrary, but they ought to be held to have to disclose that, Judge, and I think that's what the case law says. That's what 910E says. But the record is devoid of any of that evidence. If there's not any other questions, I'll conclude.
All right, I don't see any.
Thank you, Your Honors. I appreciate your time.
Thank you, folks, for your arguments. We will take the matter under advisement and issue our decision in due course. We are going to stand at recess to set up for the next argument. It may take us a few moments longer for those who are here because we're going to be changing the panel out a little bit also. So give us a few minutes. Thank you.
Thank you.